In 1905, Justice Harlan delivered the opinion for the United States Supreme Court in the case of Jacobson v. Massachusetts. And one of the many skills that one may acquire in law school if one pays attention is how to read a case, which first-year law students consume hours trying to master, performing a laborious exercise described as briefing the case, an analysis that begins most often with attempting to discover more about the controversy before the court by simply attempting to identify the pertinent facts and just the facts. A preliminary point must first be made about the facts in legal opinion, because most cases that a legal scholar or attorney might review are those matters that have been brought on appeal from a trial court or lower court. There were no witnesses who testify, there were no persons being sworn in by a bailiff or any other exciting parts of a movie court drama like a jury, and the reviewing court is only left to examine what is in the record of transcripts and pleadings and depositions and other court papers. And generally, with few exceptions, if a fact is not preserved in the record, even an objection expressed by one of the parties at the hearing or trial, it is not under consideration by a court on appeal, where the review is limited to what are called assignments of error, designated in the movies by those scenes where an attorney says, "I strenuously object, Your Honor." So if you were wondering why they always say that in the movies, consider yourself now informed. Another preliminary point must be clarified about these facts on review by an appellate court, as distinguished from the normal court dramas in film and television with which you are probably familiar. If you are observant and paying close enough attention, you may have noticed that in a courtroom drama there are always at least two sides in what attorneys call an adversarial process. And in criminal courts, which are most often the topic of courtroom dramas, there is the accused or defendant, and he is against the prosecution, or the prosecution is against him. But in civil proceedings, we generally find a complainant or plaintiff or petitioner, maybe on the People's Court with Judge Wapner, who is seeking a remedy or relief from some alleged injury that was caused by a defendant or defendants, acting individually, jointly, or separately, the same term that is used for the accused in a criminal case, if that makes it easier to remember. But there are more players in this ensemble production in a courtroom, and you may have also noticed that there is almost always a judge, man with a black robe or woman, and at least in the movies, almost always a jury, and they both serve different roles, with which you may be familiar if you have ever been called to serve jury duty. What does the jury do besides appoint a foreman? They listen to the case and the arguments during the trial, and then convene in a jury room to deliberate on the facts that were presented by both parties in the case, be they the accused and the prosecution in a criminal trial, or the plaintiff and the defendants in a civil one. During the trial, both sides will often present to the court what are called jury instructions, which is basically a juridical cheat sheet to assist the jurors, like Cliff Notes, who are not versed in the law, to provide focus for their deliberations and to keep them from getting lost in the pertinent facts and irrelevant ones, and starting heated arguments about matters that have absolutely nothing to do with the case. Arguing for hours, keeping others waiting. And if you are perceptive, you might see where this is also an important part for a litigator, because by choosing the proper instructions that tend to favor most your client, even without being in a jury room, you have already helped to decide the case. Think like a lawyer. And if so, we are to define the role of the jury. A court or attorney would say that the jury in a courtroom is essentially a judge panel of several ordinary citizens, just like an election. And it is their job, or shall we say duty, to serve as the trier of the facts, legal term of art, which by at least default leaves to the judge the duty of serving the role of the trier of those things that pertain specifically to the law. So, for instance, if a judge were to permit the jury to be provided an improper jury instruction to preserve this error for assignment on appeal of the record, we might expect a skilled attorney to rise from his seat and with the flair and command of the best stage performer to exclaim in boisterous clamor those familiar words ringing through the court, "I object." And this type of objection regarding jury instructions is most important because on appeal of these aforesaid assignments of error, on only those few occasions where the appellate court can review a matter de novo, or from the very beginning, examining all of the facts in the record, the only matters that the appellate court will review will be limited to those questions of law that may be in error. And even on those rare occasions when a de novo review is permitted, there is what is described as a doctrine of deference, and a reviewing court will generally not disturb the findings of the jury unless they are clearly erroneous, totally ignorant, leaving a reasonable person with a definite and firm conviction that a mistake has been made, a phrase you may hear very often from an attorney, and which is the language of the Supreme Court in the 1948 case of U.S. v. U.S. Gypsum Company. And for the Jacobson case, this point of jurisprudence and judicial procedure is very important. So try to remember that or write that down. A reviewing court will not overturn the facts in a case unless it is determined that they are clearly erroneous, leaving one with the definite and firm conviction that a mistake has been made. And this nuanced understanding of legal analysis we shall use as we begin to delve into the facts that were before Justice Harlan in 1905. The level of analysis here is often neglected in the current debate regarding vaccine mandates, vaccine passports, facial coverings mandates, quarantines, lockdown orders, and other particular regulations that have arisen during the current public health crisis, or shall we say in the COVID-19 response, or pandemic if you prefer. And in the legal analysis, this step is very important because it helps to develop an understanding that the courts breathe filtered air in these pandemic-inspired litigations, equipped with their masks and the high viral load that have opened the floodgates of litigation through people demanding not to take vaccines, but also for developing a legal argument. These facts are important because very often a plaintiff will have to contend with legal precedents, like in Jacobson v. Massachusetts, and will be required to distinguish those facts before the court, in that case, that are different from a matter decided by the highest court in the land. But for now, let us simply begin with the facts that Justice Harlan considered important enough to include in his Supreme Court opinion, an opinion that found only two in dissent, Justice Brewer and Justice Peckham, who in dissent provide a narrative history, very detailed, of state-supported vaccinations, which began in England in 1808, and compulsory vaccinations, which followed in the United Kingdom in 1853. And in this brief narrative, we learn that England was preceded in mandating vaccinations by Bavaria in 1807, Denmark in 1810, several German states in 1818, and Prussia in 1835. But Romania, Hungary, Serbia, and Switzerland would adopt compulsory vaccinations later. That's Hungary if you're in Henrico County. But before the end of the 19th century. And this provides a historical contextual setting that preceded a controversy for a man named Henning Jacobson in the city of Cambridge, Massachusetts in 1904. When he finally made it to court, a litigant facing off against the force of evolving science on infectious diseases, against advocates for the powerful state, espousing a state interest for exercise of their police powers in the name of public health, and equipped with readily available analogies for the argument from history. And these, as they say, are the facts, just the facts. On July 17th, 1902, it took 2 years for him to get to court. On July 17, 1902, the appellant was charged with a criminal offense by the Board of Health of Cambridge that had provided free vaccinations for all persons, but Henning Jacobson, over the age of 21, had refused. So at the outset, we know that the appellant who brought the petition to the Supreme Court was at first a defendant, or a person who had been accused of committing a crime. And for this refusal to comply with the law, which the city of Cambridge had made very convenient, even offering free vaccinations and vaccination sites, he had been fined in the sum of $5, the equivalent of about $150 today. Yet another analogous fact that finds relevance today is that the Commonwealth of Massachusetts had not enacted any legislation, not issued any executive orders to compel smallpox and vaccinations. But the city of Cambridge, for the purpose of what they proposed was a public safety measure, having found in their local jurisdiction or affected area a series of smallpox infections, had taken upon itself, under its police powers, to fine those persons who refuse to accept the free vaccines. Some of this may sound a bit familiar to those in current times, where we have several similar circumstances. The governor, the president, has not mandated vaccine for everyone. Also, in the Commonwealth of Virginia, we actually had a Department of Health that declared a communicable disease a public health threat before there was ever anything inside the area. The accused, Henning Jacobson, was not just someone who simply refused to be vaccinated on just a whimsical notion, but apparently not only presented a total of 25 arguments in defense to the trial court as to why he need not comply with the ordinance and pay the fine, but also took the time during his trial to present to the court suggestions for the jury instructions, as we discussed above. So it can be said of Henning Jacobson that at least when he was brought into court as a criminal defendant, either he or his attorney had taken some time to identify the risks, a composite risk assessment, identify the risks that had presented in his environment, his affected area, and had prepared several countermeasures to keep himself safe from harm, just like one person might decide to wear a facial covering or volunteer for a vaccine. But we all know that despite his best efforts, in the end, when his case was brought before the United States Supreme Court, his unapproved countermeasures experienced a breakthrough infection. And the question might arise as to whether he thought he was adding an extra level of protection that actually offered no protection at all, having failed to do enough homework, even if it appeared in his understanding to be a good plan. You never want to be that guy. The Supreme Judicial Court of Massachusetts found several of the total of 25 arguments raised by Henning Jacobson significant enough to preserve in the record, and were available for Justice Harlan to repeat, in his opinion, to history at the Supreme Court. And in the record, the Supreme Judicial Court of Massachusetts had included in the opinion that was penned by Justice Harlan, stated the ninth of the propositions which he offered to prove as to what vaccinations consist of is nothing more than a fact of common knowledge upon which the statute is founded, and proof of it was unnecessary and immaterial. The 13th and 14th involved matters depending upon his personal opinion, which could not be taken as correct or given effect merely because he made it a ground of refusal to comply with the requirement. Moreover, his views could not affect the validity of the statute, nor entitle him to be accepted from its provisions. The other 11 propositions all relate to alleged injurious or dangerous effects of the vaccination. The defendant offered to prove and show by competent evidence these so-called facts. Each of them in its nature is such that it cannot be stated as a truth otherwise than as a matter of opinion. The only competent evidence that could be presented to the court to prove these propositions was the testimony of experts giving their opinions. It would not have been competent to introduce the medical history of individual cases. And so, just from this brief description in the record, we began to understand that Henning Jacobson knew at least a little bit about the operation of the court, his new pandemic crisis, at least enough to bring as many as 25 individual arguments for his defense in his criminal trial, and enough to know that it might be helpful to present instructions to a jury. But he did not know when a litigator requires expert testimony, nor, apparently, that he was not an expert himself in the eyes of the court, that his personal opinions meant very little to the court deciding his guilt or innocence in a criminal case. And most importantly, he did not know exactly how to bring a challenge against the law that he refused to obey. And so he probably had a large press conference after departing the criminal court to tell the world that he would take this to the Supreme Court. So, like General Alston, Secretary of Defense, said, get the shot and stay healthy. Jacobson v. Masterson supports it. It is abundantly clear upon all evidence that a God in heaven simply does not like you, love notwithstanding, and it is not true. Or is it not that 3 generations of imbeciles are really quite enough? Get the shot! Fools rush in where angels fear to tread. This briefing is unclassified. Actually, world, my name is Major Mike Webb, and by God, I am running for Arlington Public School Board. Let's keep Mike Webb away from our schools. Honest, carry on. This advertisement was authorized by Mike Webb.